Hello and welcome to another episode on this channel. Yes, it's another day to talk about amazing stuff, and I believe you have enjoyed the value on this channel, and it is another day to deliver value. Although what I want to talk about today um, has some level of controversy in it, but we have to do it for the sake of clients, right? People who get to invest in real estate so that they are aware, they are informed, so that they will probably make informed decisions, right? So basically, I want to talk about the power of attorney. A power of attorney. A friend, look, not exactly a friend, but when we were in law school, someone stood up to ask a question and said, and instead of power of attorney, he said power of Anthony. And we all burst into laughter, right? So it's not power of Anthony, it is power of attorney. Attorney, okay? Okay, so I want to talk about the power of attorney today and to address the issue of whether it is a title document or not. Is a power of attorney a title document? A couple of clients have reached out to ask these questions, even on my brother's channel, Jeff, of on whether a power of attorney is a title document. And yeah, today I want to share my opinion on the subject matter. And yes, my name is Raymond Ijeomah, and I'm a real estate entrepreneur as well as a property lawyer here in Nigeria. So I'm going to go straight in. Of course, you know that I try not to go into a lot of technicalities. I try to simplify the conversation so that you will understand it, and you could even as well explain it to somebody, right? So, but however, today I'm going to just make a little reference to some legal stuff, but I'll still be able to explain it in a way that I believe you would understand and appreciate. So today, okay, let's go right in. Let's go right in. Okay. The Black's Law Dictionary defines a power of attorney as an instrument granting someone authority to act as an agent or attorney in fact for the grantor, also termed as a letter of attorney. So a power of attorney is an instrument granting someone authority to act for and on his behalf. The intention behind the design of a power of attorney is that you give someone an authority, you by virtue of that document empower somebody to do something for you. So say for instance you are in the diaspora and you are not in Nigeria and you want to buy a property, you can give a power of attorney to your brother or someone or your lawyer to acquire properties for you. In that way, he's not acquiring for himself, but he's acquiring for you, because that is the intention behind that document referred to as a power of attorney. So, however, of course, there are different types of power of attorney. You have the general power, you have specific power, or special power, as the case may be, or you have where the power of attorney is irrevocable. And it is this irrevocable one that is going to extend our conversation, but stay with me. So, the entire essence, the intention is just like when you say, maybe you are a parent and then you want to send your daughter on an errand, and you are like, John, go get me something, buy me something at the grocery store. And your intention from the very beginning was that he would go there and get it for you, and not that he takes it permanently for himself, or whatever you buy, or whatever you decided you sent him to get, that he takes it permanently for himself. No, the intention from the very beginning was that he should go there, buy it for you, and bring it back to you. And that is also the legal intention behind a power of attorney. That someone maybe is not available, is not around, he can't do it himself, or or on the basis of the fact that he's not maybe capable to do it at that point. The intention behind that is that he, through a power of attorney, a document referred to as a power of attorney, can now have the opportunity to still be able to carry that transaction and have someone act as though he was physically present, or he was doing it by himself. So that is the entire essence of a power of attorney. Okay, so even when we're in the law school, we're specifically taught that a power of attorney doesn't transfer title. Okay, I'm going to leave that, and I try to focus on what I need to focus on. So I went to serve in the East. I served, by service I mean NYSC, in the East, Abakaliki specifically, Ebonyi State. And having come across a couple of land transactions, I was shocked to realize that they were using the power of attorney to transfer title, to sell land, and then determined the irrevocable power of attorney to sell land. Sincerely, I'm gonna be sincere with you, I looked critically at the transaction, and I was telling the not exactly a client, I was telling the person who brought the document, he wanted to buy land. I was telling the person that something is wrong somewhere, that a power of attorney is not used to transfer title. And he now told me that that's what they use here, that is what is used in almost all parts of the East. It's popular, it's a document used to transfer title in the East. And I looked in, and I had to call some senior friends, even there in the East, and they said yes, that's what they do, but that's what they use. Okay, but I'm like, okay, it's alright. So I eventually used it. Though I had not gotten to this level, I eventually had in the East, I had to do something extra. But before I get to that point, let me establish the point. So eventually, I realized that in the East, that is what they use. And the reason that I got at the end of the day was because it is registrable, like you can register it, and then it also has a shortcut to avoid some payments at the registry. But I'm like, okay, yes, we have what we're taught at law school, the law itself, but in practice, it appeared to be different in the East. But the question is it the right thing to do? The question is it right? So I'll share my opinion, and I'll share my opinion and advise you in this regard, but I'll leave you, of course, to decide what you would want to do at the end of the day. Okay, so I'll move further. Let me read out a couple of things for you. There are a lot of cases where the power of attorney has been stated not to be, or that the power of attorney has been stated as not being a title document. Up to the Supreme Court of the Federal Republic of Nigeria has stated it clearly that the power of attorney is not a title document. Okay, yeah. Let me read this out. Written by a smart individual, so I'll just reference what he said here. Now, by a power of attorney does not convey title. Rather, a power of attorney is the authority given to the donee to exercise certain powers on behalf of the donor. It does not transfer any interest in the land, neither does it alienate the land in favor of the donee, no matter how flamboyantly written the content of the power of attorney was drawn. I like that part. Let me read that again. That a power of attorney does not convey title. Rather, a power of attorney is the authority given to the donee to exercise certain powers on behalf of the donor. On behalf of the donor, it does not transfer any interest in the land, neither does it alienate the land in favor of the donor, no matter how flamboyantly written the content of the power of attorney was drawn. It is merely an instrument of delegation. See the Black's Law Dictionary, see the cases of Nwachukwu versus Orca MFB 2016, MFB Limited 2016. There's a reference as per law authorities, Ude and Nwara, Chime and Chime. Let me read a number of other cases. The Supreme Court, in the case of Ude and Nwara, held that the power of attorney merely warrants and authorizes the donee to do certain acts in the stead of the donor, and so it is not an instrument which confers, transfers, limits, charges, or alienates any title to the donor. Rather, it could be a vehicle where this act could be done by the donor for and in the name of the donor to a third party. It is simply saying, or this authority or these lines are saying that yes, a power of attorney is not a title document, neither does it transfer, neither does it limit, neither does it charge, neither does it alienate interest to the person who the power was given to. But it could be a vehicle. As a matter of fact, it is a vehicle through which the donee, the person the gift was given to, could act on behalf of the person who gave that power. So yes, I am the owner of the land. You listening to me, for example, you are the donee, the person I am giving the power of attorney to. So in the document, I am the person who is giving you the power, referred to as the donor. You receiving it is referred to as the donee. Alright? In this context, I have a piece of land, and in that power of attorney, I designate that you should sell that property for me. Now, you can transfer interest to another person by virtue of that power of attorney that has been written by me, granting power and authority to you to give that title. But you cannot take that title. That is what the Supreme Court authority said. And remember, the Supreme Court is the highest, is the apex court, is the highest authority as far as our judicial system is concerned. I think there is a little more. Let me read it. Okay. Okay, let me quickly explain something there. In other words, the power of attorney, in essence, essentially, I haven't given you the power. You can give to every other person, but you can't give to yourself. You can give power, transfer title, sell land for me and on my behalf, receive the payment, and of course return the money to me anyway. Receive payment, transfer that title legally, and it will be as though I was the one that transferred the title. But you cannot transfer the title to yourself. A power of attorney is a tool of delegation. And by delegation, simple English, delegation, it means that you are doing something on behalf of another person. It's just like saying I give you money to go and share for some persons, and then you are taking the money for yourself. That is not delegation. You are simply taking. So instead of using a document that, okay, let me read something else. Okay, basically there are just a lot of authorities. There are a lot of authorities that explain this idea behind the idea behind the fact that the power of attorney is not the title document. It doesn't transfer title to the donee. Rather, it gives authority to the donee to transfer title or do whatever that the donor has instructed him or her to do. Right? So let's come back to logic. Let's leave the law now and come back to logic. So why are some persons, most especially in the East, using a power of attorney as a tool of transferring title? Like I said earlier, some persons say it's because it's registrable, and then it's as a shortcut to not to make certain payments. Okay, now the question is logical question. Instead of using the shortcut or the tool, the power of attorney, which is a tool of delegation, to transfer title, why not use this? Instead of delegating the person to take, why not just give the person? Does it make sense? Instead of using a power of attorney, which is a document designed to delegate, instead of using that document to delegate the person to take, why not just use the document that gives the person directly? But for some reasons, they use this in the East and some other places. But if you look critically, I've referenced law, I've referenced judicial authorities that explain and have categorically stated that a power of attorney is not a title document. It's not my words. They are not my words. I was simply reading out what even the Supreme Court has stated. Maybe there might be some practical laws in the East, or bylaws or whatever, or some territorial laws that govern them. But while in Nigeria, and the Supreme Court is the apex court, and the Supreme Court has stated categorically, and even in logical sense, largely, I may be criticized for this, but I just have to share my opinion, right? Instead of going through the tool of delegation, it's best that you give it straight up. For a couple of transactions that I've done in the East for transferring title, yes, I did their power of attorney, but I made sure that I also prepared a deed of assignment alongside. So even if you eliminate the power of attorney, the deed of assignment can stand on its own and do what it's supposed to do. Because really, the power of attorney, I guess that. So I've shared my opinion. I've also referenced authorities in that regard. So if you're going to transact, or you are transacting maybe in the East or whatever, where a power of attorney is being used as a power of attorney, my suggestion is, if that is dominant in that era, maybe you can still use the power of attorney, but corroborate the transaction by preparing a deed that transfers title to you. That is my advice in this video today. And yeah, if you love what you just watched, do it to subscribe to this channel, that is if you haven't, and then share the video, turn on your notification so that you get immediate prompt the moment I post a video on this channel. And then if you have questions, draw them in the comment section, or you want to reach out, check the number on the cover page. And on that note, I'd like to say my name again is Raymond Ijeomah, and I'm a real estate entrepreneur as well as a property lawyer here in Nigeria. Enjoy the rest of your day, and bye-bye.